64, Section 13 are each repealed.
With the consent of the House, the bill will be substituted as recommended by the Civil Rights and Judiciary Committee. Hearing no objections, so ordered. There are amendments to the substitute. Amendment 103, clerk will read.
Strike everything after the
Last
enacting
line.
clause. Correct the title.
The good lady from the 43rd to move adoption of the amendment.
Can you hear me? Thank you, Madam Speaker. This striking amendment.
Can you move
may
adoption?
I please move adoption of striking Amendment 103.
It's been moved and seconded we adopt Amendment 103. There are amendments to the amendment. Amendment 136, clerk will read.
That's 195.
195, clerk will read.
On page 1, line 27.
Last line.
14 and insert 7.
The good gentleman from the 2nd District to move adoption of the amendment.
I move adoption of the amendment. Thank you, Madam Speaker. I move adoption of the amendment.
It's been moved and seconded we adopt Amendment 195. Remarks. The good gentleman from the 2nd District, Representative Barkis.
Thank you, Madam Speaker. Sorry, the numbers were changed. Madam Speaker, I'm going to save most of my comments to the striker, but the amendments that we're putting forth and that we start off with tonight, this speaks to the time that we're going to hear about, and a lot of what we're going to be talking about tonight is time. More time for the process of the eviction, more time for tenants to be able to cure. As the striker is presented, it says 14 days. What this amendment does is that changes it to 7 days. And I just would like to elaborate a little bit on why. Back during the interim, many months ago, we sat down and we wanted to address the issue that we were hearing so much of, and that was the need for eviction reform. And one of the key arguments to this was that tenants just did not have enough time when they were facing the specter of an eviction. So we started to do some research, having a lot of personal experience in this and bringing stakeholders from both sides, actually starting with the tenants to see what was it that they needed. And it was all about the 3-day pair vacate. Not enough time upon service to remedy. So we started to look. We started with 5. We looked at a bunch of different numbers. And when we did our research, we found that 41 states in the country, 41 states are between 0 and 7 days. So 7 days, Madam Speaker, is an appropriate time to remedy. Once the tenant is late and the grace period has expired, and the landlord feels that they must serve the notice to go after this rent, to collect the rent that is due to them, they serve that notice and they're given 7 days to respond, 7 days to cure. In that 7 days, they have a chance to be able to get assistance, to find the resources to cure that, to avoid the next steps in the eviction process. So, Madam Speaker, 7 days is reasonable. 7 days works for both tenants and landlords, and I would ask that this amendment be adopted.
Thank you. Additional remarks. The good lady from the 48th, Representative Wallen.
Thank you, Madam Speaker. Thank you for the opportunity to speak against this amendment, respectfully submitted. Part of the design of the 2-week process, of the 2-week period to pay, is that many people in our state are paid every 2 weeks. So they get a paycheck, and if they're having to struggle with the rent, that gives them another 2-week pay period to get caught up, get in touch with their networks, and make the rent right. Grant County has voluntarily taken up the 14-day period, and they've found less reliance on rental assistance and less detainers. States like Tennessee, Minnesota, and Massachusetts all have 14 days. Rhode Island has 20 days. DC has 30 days, and none of these are states with the highest foreclosure rates. And even if they were, I would submit that 11 days is an okay time for us to stem the tide of homelessness in the state of Washington and stop these rapid evictions and families losing their homes. Commercial tenants in our state have 30 days to rectify their rent almost universally, and even if they don't pay their rent within 30 days, the court will allow them 30 days to make it right and stay on the premises. Respectfully asking for a no vote.
Thank you. Additional remarks. The good gentleman from the 15th District, Representative Defoe.
Thank you, Madam Speaker. This bill, or I rise in support of this amendment. As the good gentleman from the 2nd explained very well, this is a step in the wrong direction for Washington State that is going to increase our homelessness issues and that are going to reduce the supply of affordable housing that will be available for rent. And it's specifically related to the number of days that are required before a landlord can apply for unlawful detainer. The issue with the 14-day period of time is that it puts Washington State on the outside looking in for all states in the western part of the United States that have very unique property laws. Everything west of the Rocky Mountains has a unique set of property law, and the other states that are west of the Rocky Mountains have notice to vacate, days to vacate that are much less than 14. The state of California has 3 days. The state of Colorado, 3 days. Hawaii, 5 days. Oregon, 6 days. This would put the state of Washington more than twice the other states that have property laws that match and mirror our own. This is very concerning. As the good gentleman said, this would make Washington State further out than all but 5 states in our union, and these are all states that have a very different property law system: Massachusetts, Vermont, Wisconsin, Minnesota, Tennessee. This is very concerning because at the core, everyone in this body wants to see us address homelessness and reduce eviction, and that's something that we can do, but not by taking away the rights of landlords to enforce an agreement that was voluntarily entered into with a willing party. If you have this day increase go into effect, you are going to see that people are going to be much more careful with who they choose to rent. And as someone who has been a tenant's advocate and tried to get folks into rental housing, this increase in the number of days is going to limit the options for those individuals. As a legal assistance attorney for the military, I have helped soldiers get into rental facilities on many occasions. This is going to raise the level of scrutiny on those soldiers and on other tenants who might not otherwise have an opportunity to move into housing like this. Because what's going to happen, Madam Speaker, is you are going to have landlords sit back and say, I'm not going to partner with that homeless assistance program like we do in Yakima County right now. Because if something goes wrong, the landlord can always recover their property after 30 days. And it still takes 30 days. Even under the 3-day current pay or vacate system, you have a 5-day grace period. Then there's 3 days that are added on top of that. And then by the time you get your show cause hearing 2 weeks later, there's another 2 weeks. By the time the writ of restitution is filed and executed upon by the sheriff, you have a full month. And at any point along that time, if you pay the full amount that's due, you can remain in your property. So what we're doing now by extending this period to 14 days, 5-day grace period, another 14 days, and then we'll talk about some other things later on, but what's going to happen by this 14 days, we're going to end up doubling the amount of time. So it's not the 1 month that the good lady mentioned. It's going to be 2 months now, so we're going to be twice the commercial norm, and we're going to be twice what the number of days that matches with our property law system that we have effect here in Washington State. So I strongly encourage a no vote. This is fundamental to the bill, and this will be fundamental to our support.
Thank you. Additional remarks? The good lady from the 6th District, Representative Graham.
Thank you, Madam Speaker. I'm going to speak to personal experience. Having been a landlord with my mother together, we had a home that when you talk about the mom and pop landlords, we definitely fit into that category. My mom's 74 years old, and a lot of these landlords, they live from paycheck to paycheck just like the tenants do. And when you start talking about the things that we're talking about as far as extending dates, you actually are pushing these mom and pop landlords out. They just cannot afford to keep absorbing. At some point in time, there has to start being some give from the other side. The home that we had was always taken care of. If something broke, it was fixed right now, right down from a school, and the rent was always kept down because you wanted to keep that long-term tenant in there. They were in a nice home, cared for, and it was reasonable. The house that we had just got sold because of the stuff that we're talking about right now. There comes a point where you just go over the edge and it's too much. Thank you.
Thank you. Additional remarks? The good lady from the 10th, Representative Smith.
Well, thank you, Madam Speaker, and I just want to acknowledge that I think both the good gentleman from the 15th and the good lady from the 6th really highlighted the stories around why the amendment before us that moves the language of the bill from the 14-day timeline to the 7-day timeline is a reasonable request of this body, and I would certainly encourage a yes vote on the amendment.
Thank you. Additional remarks? The good gentleman from the 15th, Representative Defoe.
Yes, thank you, Madam Speaker. I'm urging a yes, contrary to my concluding remark. Yes on the amendment.
Thank you. Additional remarks? Seeing none, the question before the House is the final passage of the adoption of Amendment 195. All in favor say aye. Aye. Opposed say nay. No. The amendment fails. There are more amendments. The good gentleman from the 30, I have to read it. Amendment 193, clerk will read.
On page 8, beginning on line 28 of the
Last
striking
line.
amendment, all of subsection 2.
The good gentleman from the 31st to move adoption of the amendment.
Thank you, Madam Speaker. I move adoption of 193.
It's been moved and seconded we adopt Amendment 193. Remarks. The good gentleman from the 31st, Representative Irwin.
Thank you, Madam Speaker. With this amendment, we're striking a section out of the bill that says if you don't pay your fees, that you can't be evicted. And we're just saying that you need to pay your fees, just like you need to pay your rent. So what the underlying bill is going to do, or the underlying striker is going to do, is it's going to say you cannot be evicted as long as you pay your rent, even if you owe a whole bunch of fees. So this can be attorney's fees, this can be damage fees, this can be late fees. So here I am as a homeowner, and this is going to be a theme, as you'll see with these amendments in the underlying bill. If I'm a homeowner, and I'm talking about like a home, not a 50-unit apartment building, but just a guy who's got an extra house because he's saving for his retirement, and I'm renting this out. Somebody moves in and they break a whole bunch of stuff because they had a big party or whatever. I come out, all right, you broke this stuff, you owe me $500 because you broke this stuff and I got to fix it. So I pay to fix it because it's got to get fixed. But then the tenant doesn't pay the fee. They don't pay for the stuff that they broke, but they get to keep living there because they paid the rent. I'm out $500. I'm still out with $500, and so then the next month they're late, and they don't pay the late fee. They just pay their underlying rent. And the month after that they're late. They don't pay that late fee. So now I'm $600, $700, $800 in fees that they haven't paid me. So what I'm going to do is I'm going to get way more specific in terms of how I screen tenants on the front side. You know, I'm going to require credit scores. I'm going to require more money down. I'm going to do all sorts of things that set up barriers to protect my investment in my asset so that I make sure that I'm bringing somebody in who's not going to do all of those things. So all I'm asking for with this amendment is to say, no, let's give the homeowner just a minimum amount of protection, saying that not only do you have to pay your rent, but you also have to pay the fees that you owe. And if you don't, and if you continue to not pay the fees that you rightly owe, that eventually I can come to you and say, okay, hey, enough's enough. You know, you're not paying the money that you owe me because you've damaged this place and I paid to fix it, but you haven't paid me back. So please, please, please pay these fees. And if you don't, then I'm going to have to find a new tenant. You're going to have to go somewhere else because the underlying bill won't let me do that. And that seems pretty reasonable to just say, no, if someone owes you money for things that they've done, that they should have to pay that. And if they don't, then eventually you should be able to evict them. Because right now, with this striker, you will never be able to evict someone for not paying these fees, as long as they keep paying their rent. And that doesn't seem right. That doesn't seem like that protects someone's property rights and the property that they're renting out. This is a pretty modest request, and it will help people protect their asset, and it'll help people, take that risk on a tenant that maybe they wouldn't have otherwise. Because otherwise the answer is very simple. I either sell this single family house to someone who's just going to live in it, so now it's not on the rental market at all. Or I get so selective in my tenant selection on the front side, because it's the only thing I can do to protect myself, that a whole bunch of people who really need access to that housing will never have access to it. This is a good bill to keep units in the rental market. This is a very modest and reasonable ask, and I urge adoption. It makes the underlying bill a much stronger bill.
Thank you. Additional remarks. The good lady from the 43rd, Representative Macri.
Thank you, Madam Speaker. I'm rising to respectfully ask for a no vote on this amendment. I really can't think of any other situation where people can lose their home, something that's so critical. And what this bill intends to do is really to limit the reasons for which people can lose their home. Not to dispute the fact that when you have an agreement with a landlord, you must uphold that agreement and make payments. I really can't think of another situation where this happens. We have other remedies when one party owes another party money through the courts, and this bill does not intend to dispute that. Through lots of stakeholder conversation, the striking amendment to which this amendment is put on makes clear that the reason someone can lose their home is really about non-payment of rent, including utilities and other recurring charges. To me, it seems incredibly inhumane that we would have people lose their homes over an inability to pay late fees or attorney's fees. And so while there are remedies for that, I'm asking for a no vote. So we limit the reasons for which people can lose their home. So with that, I'm asking for a no on the amendment. Thank you, Madam Speaker.
Thank you. Additional remarks. The good lady from the 26th, Representative Caldier.
Thank you, Madam Speaker. I was listening to what the good woman from the 43rd District said, and I thought it was kind of interesting because she mentioned that it would be very cruel for somebody to lose their home. But the interesting thing is that it's not the tenant's home. It's the landlord's home. And I also think that it's very cruel to have somebody who's had an investment and to have a tenant that I've seen cases where it's tens of thousands of dollars of damage that's been done to that home. And that's the landlord's home. And a lot of times those landlords cannot afford the damage that the tenant has done. And so I'm just saying, I understand things from the tenant's perspective, but you also have to understand things from the landlord's perspective, because there's a balance here. And it's not the tenant's home. The tenant is renting the home. Thank you.
Thank you. Additional remarks. The good gentleman from the 16th, Representative Jenkins.
Thank you, Madam Speaker. I think it's very important to point out a particular case in point. My case in point. I had 6 rentals at one point, not too long ago. Saw the writing on the wall on where this was going, just like what was just said, as far as being the landlord's home as opposed to being the tenant's home. And really had to think about, do I want to stay in that aspect of real estate, or do I want to go into commercial? And I went into commercial because of this. Commercial is a lot harder. I mean, and I'll tie this in. When it's vacant, it stays vacant for a long time. Where residential, it's rented right away. So that's a good point. But you get into this type of thing, you can't afford it. I'm not a rich person. I lived basically month to month and trying to make it. I borrowed everything I could to get into each one of these. It's not easy. You really put yourself at financial risk. But what happened? This is the main point. What happened on all 6 of those rentals? They ended up being sold to people who were to live in them. They didn't continue to be rentals. So all 6 of those rentals were lost as rentals. And that's something that's going to happen. I guarantee it. Thank you.
Thank you. Additional remarks? Seeing none, the question before the House is adoption of Amendment 193. All in favor say aye. Aye. Opposed say nay. No. The amendment fails. Amendment 196. Clerk will read.
On page 9, beginning on line 20.
Last line.
Fees, strike all material through law on line 27.
The good gentleman from the 15th to move adoption of the amendment.
I move adoption of Amendment 193, or 196.
It's been moved and seconded. We adopt Amendment 196. Remarks. The good gentleman from the 15th, Representative Defoe.
Thank you, Madam Speaker. I'd like to ask this body's support for an amendment on 196. And what this amendment does is that it strikes out the word fee. Right now, under the current legislation as it's drafted, attorney's fees may not be charged against a person, a property owner who prevails in an unlawful detainer, unless, may I read from the legislation, Madam Speaker? May I read from the legislation,
Please
Madam
proceed.
Speaker? What this does is it, in an award of attorney's fees, it requires that the landlord show that the tenant did not act in good faith or willfully performed an act prohibited by the lease or the governing law, or willfully refrained from performing an act required by the lease or the governing law. And Madam Speaker, this applies even when the unlawful detainer is for default in payment of rent. So to me, Madam Speaker, this doesn't make any sense. If you defaulted, how can you default on a term of a lease and still be acting in good faith? I think this is some excessive language that is going to open up findings of good faith when in fact the tenant has defaulted on the fundamental term in which the landlord entered into the agreement with them so that they could occupy the premises. So I would ask for this body's support of the amendment and try to clean up the language a little bit here on this section of 1453. Thank you.
Thank you. Additional remarks? The good lady from the 27th, Representative Jenkins.
Thank you, Madam Speaker. I rise to respectfully ask for a no vote on this amendment. The good gentleman from the 15th talked about a default judgment. Let me give you a couple of examples of attorney's fees that we've seen in default judgments. A $2,500 fee for a default judgment, a $2,800 fee for a default judgment when the rent due was $600 in each of those cases. Those are not reasonable attorney's fees. The underlying striker is attempting to set a standard so that we make sure that the fees that folks are charged are not loaded up. These fees that we're talking about, whether they be attorney's fees or other fees, are one of the primary reasons why people are being priced out of their housing. It's not just about their rent. It's about all these kind of exorbitant fees that are added on. And for attorney's fees, there's really no limit, no standard. It says reasonable attorney's fees right now. So the striker is trying to say, this is what's reasonable. You have to be able to show that somehow the tenant has acted in bad faith. Now, an amendment that might have been more acceptable would have been one that had set a limit on attorney's fees. For example, in Minnesota, by law, they set their attorney's fees at $5. Okay, that could be one. My guess is that not everybody in this room would agree that that's a good that's a good fee. But we have to be able to set some sort of standard here so that people aren't getting priced right out of their tenancy, right out of their home, less based on the rent that may be overdue and more based on the costs that are related to the attorney's fees that then, if they are evicted, prevent them from getting another apartment. So it's for that reason that I ask for a no vote on this amendment, Madam Speaker.
Thank you. Additional remarks? The good gentleman from the 15th, Representative Defoe.
Thank you, Madam Speaker. I appreciate the comments from the good lady from the 27th, but unfortunately, I see this in a different light. What the current legislation does, and what my amendment seeks to fix is that this blocks the court from awarding reasonable attorney's fees. So even if the attorney's fees are reasonable, as the court determines, they still cannot be awarded unless the court finds that the tenant acted in bad faith. And the tenant, we already know, defaulted on the rent. So what's the additional criteria that's required to establish bad faith? That's not shown in this particular piece of legislation. And so while we could have set some sort of default standard, the reality is that the court is already determining that these fees are reasonable. And now in 1453, if it passes as is, the court won't be able to award what it has determined is reasonable unless they can make this secondary finding, and there's no criteria to establish how they can in fact make that secondary finding. So this risks eliminating landlords being able to recover any attorney's fees for what it can be a very expensive process. You could have 1 month of unpaid rent, you can have the litigation costs of pursuing getting your property back, you can have interest, you could have damage to the property. All that would be prohibited unless there's this secondary finding, of which there's no way to establish how to make that finding. So again, I ask for this body's support of the amendment, just to dial it back just a little bit to where we can actually get reasonable attorney's fees for a landlord who successfully prosecutes a case for unlawful detainer. Thank you.
Thank you. Additional remarks. The good gentleman from the 31st, Representative Irwin.
Thank you, Madam Speaker. And just to build on that theme, if we remove all protections for a landlord, if the contract means nothing, if someone can always stay there and we can never collect any of the fees that would go along with someone failing to follow the terms of their lease, the only thing we have left to do is either to sell that house as a single-family house and take it out of the rental market forever, or really dial down on our tenant selection and have all sorts of barriers to entry for folks who want to rent that place. You're only going to be able to rent it to somebody who's got an incredible credit score. You're only going to be able to rent it to somebody who you absolutely know is going to follow the law, or not follow the law, but follow your contract, because if they don't, you will have no recourse. If we don't amend this underlying bill, all we're going to do is shrink the rental pool in Washington State, and that helps no one. Please adopt this amendment. Give homeowners just a modicum of protection so that we can keep these units inside the rental market and not create these barriers to entry.
Thank you. Additional remarks. Seeing none, the question before the House is adoption of Amendment 196. All in favor say aye. Aye. All opposed say nay. The amendment fails. There's one more amendment. Amendment 194. Clerk will read.
On page 10 of the striking
Last
amendment,
line.
at the beginning, 5.
The good gentleman from the second to move adoption of the amendment.
Thank you, Madam Speaker. I move adoption 194.
It's been moved and second we adopt Amendment 194. Remarks. The good gentleman from the second district, Representative Barkis.
Thank you, Madam Speaker, and I will keep this brief. Madam Speaker, we've heard a lot about this bill, and again, we'll save for the final, but what this amendment does, there's a major part of this particular piece of legislation. It talks about judicial discretion. So after the whole process is done, there is an opportunity to remedy the default. And in the bill, in the striker, it gives broad judicial discretion about how that can happen, the time frames, and how the process works for a person, the defendant who has lost, to actually have an opportunity to remedy. What this amendment does is it changes that a little bit, and it puts it in a situation where it brings that balance that we've been talking about, the fairness piece that we've been talking about for the plaintiff. If the tenant has not paid their rent over the course of now almost a month, 14 days, all the time, the court actions, everything else, they should have those funds. And then what this amendment asks is that they put 1 month's rent with the courts to affect that remedy opportunity through the judicial discretion. And then the court can stay that, and if that is the case, then they have 5 days to do that. And then if there are fees, and there are legal fees that by some partner in this bill that are not, with these amendments that weren't adopted, then they would have an opportunity to make payments over 3 months for those fees. So again, it's a fairness aspect that helps the landlord recover the loss, also helps the tenant in a remedy process to be able to stay that and to come back to the House. It also puts a piece in there that does not allow this to happen more than once a year. Because we've seen over in the history of doing property management where this happens time and time and time again. Start, stop, start, stop. So I'm asking for the body to adopt this amendment to make the judicial discretion a little fairer for both parties.
Thank you. Additional remarks. The good lady from the 43rd, Representative McCree.
Thank you, Madam Speaker, and I want to express my appreciation and gratitude to the member from the 2nd for lots of conversation, particularly around this issue of judicial discretion. But I'm rising today to ask for a no vote on this amendment. What this amendment asks is that someone pays, comes to the show cause hearing and pays 1 month's rent at the show cause hearing, which essentially negates the whole purpose of judicial discretion. In the striker, which this intends to amend, the court is required under the limited terms of judicial discretion to give the tenant up to 5 days to pay that 1 month's rent, to show that they have the ability to do that. This amendment also requires that the court can give up to 3 months, but would require 3 equal installment payments when behind, where as the idea of 3 months is a good one, I think, the striking amendment allows the court to give up to 3 months and flexibility in how those payments occur based on the court's discretion. So while I think there are fine points of dispute here, I think that this amendment would undo the benefits that judicial discretion would have, not only to the tenant, but to the landlord as well. And for that reason, I'm asking for a no vote. Thank you.
Thank you. Additional remarks. Seeing none, the question before the House is adoption of Amendment 194. All in favor say aye. Aye. All opposed say nay. No. I think the Speaker is going to call division on that one. The Speaker's about to open the roll call machine. Has every member voted? Would any member like to change their vote? The Speaker's about to lock the roll call machine. The Speaker's locked the roll call machine. Clerk will take the roll.
Madam Speaker, there are 43 yeas, 55 nays, 0 excused.
The amendment fails. Now the question is the adoption of the striking amendment, Amendment 103. Remarks. The good lady from the 43rd, Representative McCree.
Thank you, Madam Speaker. This striking amendment, do I have to move it again? Madam Speaker?
Yes, please proceed.
Oh, thank you, Madam Speaker. This striking amendment is the result of lots of conversation about the original bill and lots of, I think, good creative ideas that came out of those discussions. I'm particularly grateful to the member from the 27th District and the member from the 2nd District, the 15th and the 31st, for engaging in extensive conversation about how to improve this bill and ensure that we're bringing some balance in our approaches. And with that, I ask for support and will speak to the underlying bill.
Thank you. Additional remarks. The good gentleman from the 2nd, Representative Barkis.
Thank you, Madam Speaker. I will save my remarks to the final bill too, but I will just say that I do appreciate the opportunity to work with the good lady from the 43rd on offering some amendments to this particular striker. I'm going to urge a no vote, but I will talk more about it in a second.
Thank you. Additional remarks. Seeing none, the question before the House is adoption of striker 103. All in favor say aye. Aye. Opposed say nay. No. The Speaker called division. I'll divide the House. The Speaker's about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Would any member like to change their vote? The speaker's about to lock the roll call machine. The speaker has locked the roll call machine. The clerk will announce the total.
Madam Speaker, there are 55 yea, 43 nay, 0 excused.
The amendment is adopted. There are no more amendments. With the consent of the House, the rules be suspended, and engrossed substitute House Bill 1453 is advanced to third reading. Hearing no objections, so ordered. Engrossed substitute House Bill 1453 on third reading and final passage. Remarks. The good lady from the 43rd, Representative Macri.
Thank you, Madam Speaker. We are facing a true eviction crisis in our state. This is related to the housing crisis, which we have heard talked about on the floor of this chamber several times during the course of this day. As I mentioned earlier, I can think of no other instance where somebody can lose their home so quickly. It's important to note that 9 out of 10 evictions in our state are related to non-payment of rent. And in a recent study in Washington state, we found that when folks have been evicted, close to 10% of them only have been able to find another home, meaning that eviction is directly related to the crisis of homelessness that we're experiencing in our state. The consequences are immense: displacement, kids taken out of their schools, parents losing their jobs, entire communities being disrupted. We know that to address the housing crisis, we need to do many things, and we've talked about them today, but we can't ignore the fact that people need security in their homes, and that is what this bill does. The bill focuses on 3 main areas. First, as you've heard, it extends the period in which people can pay rent when they have fallen behind from the current 3 days to 14 days. It allows the court to have some limited judicial discretion to take in the full circumstance when contemplating a judgment where somebody can lose their housing. And finally, it makes important updates and revisions to the notices and summons forms, because we see a high rate of defaults in eviction, meaning people don't even show up to court. Because, Madam Speaker, many people don't understand the process, or in some cases, people don't even understand the language in which the form is given to them. So these important improvements will bring stability to families in Washington state. They will help to address our homelessness crisis, and they will ensure that we can have strong communities. So I urge your support of this bill and ask you to vote yes. Thank you.
Thank you. Additional remarks. The good gentleman from the 2nd District, Representative Barkis.
Thank you, Madam Speaker. And I'm going to start by thanking the good lady from the 43rd. She is correct in the work that has been done, the conversations that have been had. But I will say that this bill helps, but it is not the solution. Sometimes we've been hearing so much about eviction causes homelessness. It used to be we talked about eviction as part of one of the reasons for homelessness, but in recent months, it's become a direct line. Eviction equals homelessness. And a lot of times we forget to ask the question, or the second question that is, what was the cause of that eviction? Is it non-payment of rent? Why was it the non-payment of rent? Could it be an addiction? Could it be other issues? Could it be just carelessness or irresponsibility? You see, I have a lot of experience in this arena, as most know in this body. I've been doing this for 25 plus years. And so this interim, we started out with a process. We went for the problem statement. We asked the housing lines. We asked those who are in the tenant side of the house to say, what do we want to work on? Eviction reform. What's at the crux of it? To pay or vacate. What do we need? More time. So that's what we did. The stakeholders got together and we put forth, for the first time, progressive got it out there, proactive solutions, bills to get at this issue. This bill, unfortunately, took it to the next level. It goes too far. It adds too much time. It goes out of balance. As you've heard from my colleagues tonight, it's out of balance. It focuses too much for the tenant and not enough for the landlord. The landlord is this small business. The landlord is the moms and pops. The landlord is all those who we've talked about who provide this integral supply of housing that we so need in this state. So why is it that we're going to make it more difficult? The good lady from the 27th enlightened me on one of my amendments and talked about the costs of some of these judgments. But let me give you another little story. By the time most people come to me for service for help, they've been dealing with a tenant that's been in default for months. And I have helped, I can't tell you how many, tens, hundreds and hundreds of people that have come to me in some form of situation, been dealing with a tenant who has not paid their rent. And again, there's always a secondary issue. And by the time they get to me, they've been working with this person that's in their house, trying to help them, making arrangements, letting them go. And months and months and months go on. And so by the time they come to us and we start this process, it takes time. This bill adds even more time. By the time we get through the 14 days and all the other pieces and the judicial discretion, the 5 days, we're talking about almost 2 months, 50 days plus. So on top of the time that they've been, so I give an example, 4 months a person was working with somebody, but they had loss of rent of $4,500, appliances that were damaged, $3,000, carpet that was damaged, $7,000. It was almost $16,000 worth of damage to their house. And this young couple, they didn't have the money to take care of this. They were in a situation where they were going to have to borrow money. They were in a situation where their house was damaged. So again, I just ask for consideration for fairness. This is a good product. I know it's going to get worked on more. I know we're going to get there's some good things in this bill. The notification, the languages, the access to help, all the different things that came out of this collaborative work. But there's just a few things, the time, that's why we asked for the amendments. 14 days is too much. The judicial discretion goes too far. We needed this to be something that would work for both tenants and both landlords. Let's keep the supply of housing. Let's help the landlords. Let's help the tenants who truly need the help. But let's not forget to ask that other question. Why? What's causing them to get to this point? So with that, I ask for this body to vote no on this bill tonight. And let's work on something that's a little more reasonable for both.
Thank you. Additional remarks. The good gentleman from the 15th, Representative Defoe.
Thank you, Madam Speaker. I know it's late and we've all got important things to continue to work on, but this is a personal issue for me, and I really want to share with you some things about this bill that I hope this body will consider before they take their vote. The good lady from the 43rd has been very kind to me, very gracious to me in including me in this process, and I want to thank her for that. As the gentleman from the 2nd said, there are some good things in this bill. It produces and it requires that may I read from the bill?
Please
Madam
proceed.
Speaker. It produces and maintains on the Department of Commerce website translated versions of the notice to pay or vacate in the top 10 languages spoken in our state. That's a good thing, Madam Speaker. That will increase access to justice. That will increase fairness. That will increase opportunity for folks to avoid losing any type of situation that they live for not a proper reason. It also, Madam Speaker, it also provides information on the Department of Commerce website, information where tenants can access legal or advocacy resources. That's a good thing, Madam Speaker. As a property owner, as a tenant advocate, as a military lawyer, so many times in these situations, all you want to do is connect up the tenant with an advocate. Connect up the tenant with a legal resource who can then say, hey, this is where you stand. This is what's going to happen. Here are some of the options. Engage with the landlord. Show up to court. Go to the mediation that's been proposed. Let's solve this problem. And this moves it in that direction, and for that I'm very grateful. But there are so many other things in this bill, Madam Speaker, that are going to cut against the things that we all want to solve in this body. My parents, Madam Speaker, for most of my adult life, have lived in a fourplex. They live in one unit, and they rent out the other 3. And once my dad wasn't able to work at the post office anymore, that was his job. He took care of this property. It was one property. And the rent from the other 3 units paid my father's mortgage. And in the many years that he had this property, Madam Speaker, he didn't evict one person. But under this bill, if it ever came to that, if somebody didn't pay their rent for whatever reason, my parents would not be able to pay their mortgage for up to 2 months. And then, on top of that, they wouldn't be reimbursed for the damage and the lost rent that they suffered under the provisions of this bill. And that's why it's personal for me, Madam Speaker. Because there's no safety net for my parents. They can't go to the bank and say, we passed this law, and so the tenants have a longer time. Can I have a longer time before my credit gets impacted, before I can't buy a car, before I get a foreclosure notice for my property? Because at the end of the day, Madam Speaker, this is a social problem. And what this bill does is it puts the full burden on the backs of individual landlords for the challenges that tenants are facing. And we should help the tenants. And some of the things in this bill help the tenants, Madam Speaker, they do. And the good lady from the 43rd has worked very hard to elevate those provisions within the bill. But as it currently stands, Madam Speaker, this pushes a heavy burden on small landlords in this state and big landlords in the state, frankly. And we want big landlords in this state. There are sophisticated real estate operators who do not base themselves in this state, but they may be in New York, or they may be in Mexico, or they may be in the Middle East, and they're deciding where they're going to spend their development dollars, and they're looking at the decision that we're going to make tonight. Do we want to incentivize them to do their new developments in Portland, or in Vancouver, BC, or in Denver, Colorado? Or do we want to keep them here in our state? Do we want to keep them building in downtown Seattle? Do we want to keep them building in Tacoma? Do we want to keep them in these areas? I say yes, Madam Speaker. That's what I would like to see. And for the small landlords, because this whole state, a large part of it is not Puget Sound, Madam Speaker. A large part of it are the small landlords who don't have some of these issues that have made the headlines on some of the tiki apartments and some of these other challenges that really have, I think, gotten people's emotions very high for good reason. But a lot of the state is not that. A lot of the rental property owners in this state, Madam Speaker, are like my parents. The Yakima Valley Landlords Association, the number of properties owned by those members, the median number of properties owned is 1, Madam Speaker, at the Yakima Valley Landlords Association. That's what this state looks like. That's who this bill is going to impact. And the things in this bill, Madam Speaker, that are very challenging, and if I may read from the bill. May I read
Yes,
from the bill, Madam Speaker?
Please proceed.
One thing that is very troubling that hasn't come up is the judicial discretion that's in this bill. This would allow a judge to step in on somebody like my parents and tell them, this person's in a very hard situation. You have to let them stay beyond what you've agreed to, beyond what your contract says. And Madam Speaker, I believe that that has significant implications for our state. And it has significant implications for the Constitution of the United States. Because, Madam Speaker, in my view, that is a takings without just compensation, which is prohibited by the Fifth Amendment to the United States Constitution. There are big problems with this bill. There will be challenges to this bill. And I hope that we can block those tonight. I hope we can avoid that expense for the state and the expense for the individual landlords who are going to suffer under this legislation. And we can keep working with the well-intentioned people, the tenant advocates who have been so kind to me and who have engaged with me, and the leadership on this bill, including and especially the good lady from the 43rd. Madam Speaker, please, I encourage this body, I implore this body to, for tonight, vote no on this bill, and let's go back to the table, let's go back to the drawing board, let's take into account not just the tenant advocates in Puget Sound, let's take into account all the people of Washington State who have an interest in this very important piece of legislation here tonight. Thank you.
Thank you. With the consent of the House, we will suspend House Rule 13C to continue working past 10 p.m. Hearing no objections, so ordered. Nice try. Additional remarks. The good gentleman from the 14th, Representative Corey.
Thank you, Madam Speaker. I want to rise today to say we can do better. This bill is not where we should be headed. Hurting landlords hurts renters. Hurting landlords hurts renters, and hurting renters hurts affordable housing. I want to talk about unintended consequences, Madam Speaker, because that's one thing we're missing out. And what are the unintended consequences for the tenants that are going to be impacted by this legislation? We've heard stories tonight from other honorable representatives about situations they've been in, or selling their homes to moving it from rental to single-family home. What happens when these small properties are sold either for single-family home or renters? What's the impact on the tenants? It's not good. At best case scenario, that home is sold to another person who keeps it in the rentals market, but that home's appreciated. Therefore, rent is going to go up so that whoever's bought it is going to, get money back, return on their investment. So the renter's going to, their income, the money rent is going to go up there. Sorry, it's a little late. That's the best case scenario. The worst case scenario is you're going to have a tenant that's going to get evicted because now that home has been sold to somebody who wants to live there permanently. Hurting landlords hurts tenants. This is not the way forward with affordable housing. This is not a Republican issue, it's not a Democrat issue. The good gentleman from the 2nd has brought up that the landlords are sitting here at the table saying we're willing to work with you. But this is not working with them, this is working against them, and this is going to hurt tenants. It is going to hurt tenants. Please let's stop, figure out what we're doing so it works for both sides. This needs to be a partnership. There are unintended consequences here, and this is going to further drive down supply, drive up prices, and continue to cause affordable housing crises across the state. Please vote no. Let's fix this problem together.
Thank you. Additional remarks. The good gentleman from the good lady from the 27th, Representative Jenkins.
Thank you, Madam Speaker. Madam Speaker, about 18 months ago, I read this book written by Matthew Desmond called Evicted. And it really changed my life, actually, in terms of thinking about these issues. I was really struck. The book is about evictions. It's a nonfiction book, and it studies a city in my home state, Milwaukee, and what happens to people, both landlords and tenants. One of the things Mr. Desmond said in his book, may I read a quote quickly, Madam Speaker?
Please proceed.
No moral code or ethical principle, no piece of scripture or holy teaching can be summoned to defend what we have allowed our country to become. Eviction is a cause, not just a condition of poverty. That was throughout this book, and it struck me very deeply, and it's why I decided to start working more deeply on this issue. But, Madam Speaker, what I really want to talk about in my comments is to say the thing I'm struck by all of the speeches you've heard tonight is that we're all seeking balance here. And I get that everyone has a kind of a different idea of balance. I think we are coming, if you think about it like a teeter-totter, we're coming closer together on the teeter-totter, but it's still kind of going back and forth a little bit. But I want to be clear that there's a lot of things in this bill that have been done and that were done from the very beginning to balance toward landlord interests. Things like providing landlords with a more efficient way of enforcing their writs of restitution in order to avoid unnecessary court filings, and mandating that tenants can't be restored to their tenancy unless a late fee is paid along with attorney's fees. So there are a number of ways that the good lady from the 43rd is trying to balance here. I understand that part of what people are saying is we haven't achieved that balance yet. We need to move this bill off the floor of the House. We need to think about what it is that Mr. Desmond said in his study of evictions in Milwaukee and what the same thing is happening here in this state. And then as we move forward, I'm fully committed to trying to work and find the right balance here. But right now, in the law as it is, our balance is off, and it's all on one end, I think. We need to bring things more to the middle, and I think this bill does that, and I'm absolutely committed to continuing to work on this bill to bring it to a full balance that everyone can feel good about. But I want to vote yes on this, and I hope you will too. Thank you.
Thank you. Additional remarks? The good gentleman from the 18th, Representative Vick.
Big dinner. This button's tough tonight. I'll skip that. So this is a tough bill, and it's not a tough bill because I'm questioning where I'm going to vote. I'm a no. It's a tough bill because we obviously have a common goal. It's around affordable housing. It's around access to housing. It's around keeping people off the streets, and that's what we all want. But as the lady from the 27th somewhat alluded to, we could not be farther apart on what the solutions are. My concern with this bill is very similar to my concerns with a lot of the business regulation bills we put out there. And it's that this legislation that we're about to vote on is not going to be too much of a burden on those who are well-heeled and well-financed and publicly traded and have really good lawyers. This bill is not going to have much of an impact on folks living in multiple $1,000 a month skyscrapers in downtown cores. This isn't going to have a big effect on the waterfront property in Vancouver, Washington. What's going to happen here is that the mom and pops, as you've heard, are going to go to their accountants, are going to go to their books, are going to do the risk-reward analysis, and they're going to say the risk purely outweighs any possible reward I'm going to get out of this house. You know, you heard from the gentleman from the 16th and the lady from the 6th, if you own one or two or a couple houses, if you go a month or two without rent, you're done. You're in the red. If you own a high-rise and your building's 75% full, you're breaking even at that point. This is what we're concerned about. We're concerned about the fact that a $600 apartment in rural Washington is just going to go away. It's not going to be there. You're not going to be able to find it. You're not going to be able to rent it. You're not going to be able to be evicted from it because it's not going to exist. This legislation, plain and simple, is not going to be of any consequence to the folks at the top, to the folks with the money, to the folks with the marketing budgets, to the folks who are staying in those new glitzy high-rises. It's going to hurt the rest of us around the rest of the state who have real housing problems. I ask you to vote no.
Thank you. Additional remarks? The good gentleman from the 15th, Representative Defoe.
Madam Speaker, just one last anecdote to share that in the hopes of persuading one or two of my colleagues. In 2010, Madam Speaker, I was involved with the Yakima County Homeless Action Network, and that was at the inception of the VASH program, the Veterans Assisted Supportive Housing Voucher Program that came down from the federal government and gave opportunities to local public housing authorities to house veterans, and along with some other individuals, not through the VASH program, but through the Yakima County Homeless Action Network. And at that time, what we did, all the volunteers on the Homeless Action Network, we went out and we looked for landlords who would agree to participate in the program, and there was some extra funding that came along with that, $500 that we could provide for security deposits for these individual properties. And it was a tough sell, Madam Speaker. It was a tough sell back then to find landlords who would agree to participate in the program, but we found them, and we found them. And $500 was just enough to get through the process as it was. And those programs, I'm very happy to say, continue to exist today, and we continue to expand some of those programs, especially the VASH program, Madam Speaker. But under this bill, those landlords will be gone. We will lose all of the landlords who have stepped forward to volunteer in that program, because $500, as we've heard many times during the amendment debates and during the actual debate on the bill itself, the cost will exceed $500 by many, many fold. And so, Madam Speaker, if we really want to get at a very key tenet of eliminating homelessness in our state, this is the wrong direction for doing that, because we are going to lose the private participation from folks who have stepped forward and said, yes, we want to provide our property as the vessel for permanent supportive housing for homeless individuals in our state. And just in Yakima County alone, Madam Speaker, those numbers are more than 100. That's more than 100 people in Yakima County who, under this bill, will lose the landlords, and those people will be homeless once again.
Thank you. Additional remarks? Seeing none, the question before the House is final passage of engrossed substitute House Bill 1453. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Would any member like to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Madam Speaker, there are 54 yeas, 44 nays, 0 excused.
Having received a constitutional majority, engrossed substitute House Bill 1453 is declared passed.